Welcome to Jagma Talks. Today I am going to discuss the Indian Contract Act 1872. Students, those who are appearing CA, CMA, graduation or law, they can revise the whole chapter of Indian Contract Act within a time span of 5 to 10 minutes. Therefore, I request all the students, those who are appearing these examinations, please hear my lecture so that you can have revision within very shortest time. Thank you. Now I am going to tell you the definition of contract. A contract is an agreement made between two or more parties which the law will enforce. According to section 2H, a contract is an agreement enforceable by law. An agreement comes into existence by the process of offer by one party and its unqualified acceptance by the other party. So this is all about the definition of a contract. The party who enter an agreement must agree upon the subject matter in the same sense and in the same time. There must be consensus ad idem. So both the parties must have to accept at the same time and in the same sense. An agreement may be a social agreement or a legal agreement. A social agreement is that which does not give rise to legal consequences. But in case of its breach, the parties cannot go to law court to enforce a right. So this is the problem in case of a social agreement. We cannot go to the court to enforce our rights of the parties. But in case of a legal agreement, the parties to the agreement can go to the court to enforce their rights in case of breach. So this is all about what definition of the contract. Now comes what are the most essential elements of an Indian Contract Act. When we say that there is a contract, so it must have some essential elements. I will tell you these elements in very shortcut manner for your revision. There must be an agreement. That means it involves parties, one party making the offer and the other party accepting it. Next essential element, that is the parties must intend to create a legal relationship. So there must be a legal relationship. Third one is the party must be capable of entering into an agreement as regards age and understanding. That is the third essential element. So capacity of the parties is very important. Fourth one, the agreement must be supported by consideration on both the sides. So there must be a consideration in the agreement. Fifth one is the consent of the parties must be free and genuine. So the consent must be free and genuine. Sixth essential element is the object of the agreement must be lawful. That means whatever the object of the contract is there, that should not be unlawful. So it must be lawful. The terms of the agreement must be certain and capable of perform. That means if you are entering into an agreement which is impossible, then it cannot be an element of Indian Contract Act, essential element of Indian Contract Act. The next essential element is the terms of the agreement must be certain and capable of performance. And the last essential element, the agreement must not have expressly declared as void. So these are all what essential elements of contract. Now comes classification of contracts. So there are different types of contracts are there. So let us have a brief idea on classification of contracts. So number one is void agreements. So void agreement means an agreement not enforceable by law. Next comes that is void contract. A contract which ceases to be enforceable by law, that is void contract. Then comes voidable contract. Voidable contract means a contract which is enforceable by law at the option of one party thereto, but not at the option of other. That is voidable contract. Now, what is illegal agreement? An agreement which involves transgression of some rule of basic public policy and it is criminal in nature or immoral. It is not only void as between the immediate parties, but it is also tends the collateral transaction with the illegality. So these agreements which are immoral or criminal in nature, they are all called illegal agreements. Next comes express contract. What is express contract? A contract in which terms are stated in words, that is written or spoken by the parties. Next comes implied contract. A contract which is inferred from the circumstances of the case, from the conduct of the parties. That is known as what? Implied contract. Next comes quasi contract. An obligation created by law regardless of the agreement. That is called quasi contract. Next comes executed contract. A contract which is wholly performed by both the parties. Next comes executory contract. A contract in which promise of both parties have yet to be performed. That is called executory contract. Partially executed. That is a contract in which one party has performed his obligation, but the other party has yet to perform his obligation. Next comes that is unilateral contract. Unilateral contract means a contract in which only one party has yet to perform his obligation. Next comes that is bilateral contract. A contract in which both the parties have yet to perform their obligation. So these are all about the definition of a contract and classification of contract. So a student, when he is going to appear any examination, just before appearing the examination, if he wants to have a revision, then please hear my lecture. Thank you. Please subscribe.